Good morning and welcome to News on the Block Leasehold Knowledge Week. We're going to be bringing you 8 different sessions over the next 4 days, so we hope you find them useful. Quick thank you to our sponsors, Foresight, Realty Law, Blackguard Insurance, Chandler Harris, Pearlygate Maintenance, BBIS Commercial Heating, JPC, Towergate Insurance Brokers and PPL Fire Protection for their support. Today's opening session is brought to you by Tristan Salter, Barrister from 5 Paper. Tristan is able to advise on the frequent crossover of property issues in the realm of company law or insolvency, advising on shareholder rights in property companies or the complex issues that emerge when a landlord or tenant becomes insolvent. He accepts instructions in all aspects of property law and a real focus on leasehold and trusts of land. So during the session, please feel free to post any questions you have using the Q&A button in the middle at the bottom, and we will endeavour to get as many questions answered at the end of the session. So without further ado, I'm going to hand you over to Tristan. Tristan, good morning. How are you today?
Hi, Charlotte. Thank you for that. That's great. Little introduction. Hi, everyone, and welcome to the first of these talks. I'm really excited to be talking to you today about what's been going on in 2020, which is good. So without much further ado, I'm going to be dealing with a case review of 2020. As Charlotte said, ask any questions and I'll try and answer them at the end. If I don't get round to them, I will take a note of them and make sure I circulate an email with the responses as well. So first of all, the presentation. Hopefully now you can all see my screen and what we're going to be dealing with today. First of all, 2021 looks like it could be a dramatic year in the leasehold sector. There are going to be reforms and changes of the whole way leasehold works. Obviously, 2020 was a pretty strange year as well. And as we come up to the anniversary of lockdown, things have massively changed since last March. So what I want to do is look at the cases that I think are important in 2020, but importantly, put them into context as what we can learn about them for 2021. So therefore, what do I think are going to be some of the big issues in 2021? I've got 4 big issues that I'm going to talk about, and you'll see at the end of the presentation how these somehow link to some of the things and the cases I've been talking about in 2020. First of all, the top left is a picture of an article from the Financial Times about the cost of service charges in residential blocks. This article is really interesting and it delves into the costs that people are becoming more and more aware of, and highlighted that one service charge for this year was at £6,500 for a block near the American Embassy, and people, whatever their income, are struggling to afford them. As I said, there's already a focus on leasehold as an ongoing model in the future, and the Department of Housing has said that legislation will be introduced to change the process for extension of leases and remove ground rents. But we are looking at the 3rd session of Parliament, sometime maybe September or October, before anything is actually introduced. My colleague Elizabeth England will be talking about service charges later on today, and definitely stay tuned for that one. The top right is obviously a picture of about the cladding issues. We all know that this is going to be a huge issue in 2021. We've recently seen more money for certain blocks, those over 18 metres, but there are still unanswered questions, including what happens to those blocks which are lower than 18 metres. One thing I also expect to see is what we might call a defect scandal. As these properties are being investigated for fire safety works, more and more issues are actually coming out of the literal woodwork. So we're seeing problems in the design and build of the properties that are being affected by these intrusive surveys. So that's really going to hit home because that's not covered by any of the funds, and we'll have to question whether or not it's covered by any of the insurance policies. I know that, again, there's going to be a talk on Thursday by Dr. Sean Lundy about the Building Safety Fund, and that's going to be one to definitely tune into, which I think is going to be really important because the Building Safety Fund imposes additional duties on those in control of properties, including applying for funds, which is going to be very, very interesting about what challenges we see when a building owner has failed to apply for available funds. The bottom left is a picture of a Victorian high street, and it's a bustling high street, which is probably very different from what is out in London today, especially on my walk into work today. The scene is very different for the retail landscape at the moment. The stats suggest that there have been 850 job losses per day in the retail industry in 2021, and commercial leases are under pressure in a way that hasn't been seen before. There is a huge growth of company voluntary arrangements, which specifically target landlords and reduce their rents. A number of cases are going to come before the courts in 2021, including in relation to Cafe Nero and New Look, and they will look at the test about unfair prejudice, given that rents that landlords are being asked to accept is much below what they signed up for, and some are linked instead to turnover, which is a fundamental shift in what the agreement that was reached. Finally, the bottom right. And will 2021 be the year the government bans no fault evictions? Back in December 2019, before we even knew about anything to do with pandemics, the government announced a plan to remove Section 21 notices. And quite obviously, this timing has been delayed by the pandemic. But we've seen an era and a decade of increasing regulation of Section 21. And I think it is likely that they will ban mandatory grounds of possession with some nuanced changes. So after that introduction about what to expect in 2021, I'm going to look at 4 cases in 2020. And I'm trying to spend about 10 minutes on each. And I think they're really interesting. Maybe not the most standout cases of 2020, but I think they're the cases that teach us the most about the future changes. I'm very sorry, therefore, if your favourite case of 2020 isn't on the list. Please tell me at the end if you have your favourite case of 2020. Obviously, we really enjoy leasehold nerds here, so please tell me what your favourite case is of 2020 if I haven't covered it. But without too much further ado, I'm going to start with these 4 cases and what they're talking about. It also happens to say that there's quite a range of these cases. They go from the Supreme Court all the way down, and they really do look at how the relationship between leaseholders and tenants and lessees is developing. The first of these cases takes us straight to the Supreme Court and the decision of Duval versus 11 to 13 Randolph Crescent. The basic facts of this case: the landlord was a freeholder of the blocks, which contained 9 flats. They were all let out on long leases. It was also the management company, and the leaseholders were all members of that management company. And I'll be coming back to the issue of management companies later on. Common in these leasings, there was a provision which said the landlord must, at the request of the lessees, enforce certain covenants. And that's very common, as we see in these residential settings. In the case of Duval, there was an absolute covenant against the lessee from cutting into any roof, wall, ceiling, or service media. And you'll see that that clause is highlighted there at 2.7 on the slide. This is a common way of ensuring that leasehold rights are protected. And this covenant, like others, was on the face of it conditional on an objecting party requesting enforcement and providing security. I'll come on to that term in a second. So what to look at first of all is these 2 clauses, 2.6 and 2.7, that are in the lease. First of all, 2.6, that was a qualified covenant on improvements. That was essentially where the landlord said, I will agree to some improvements. And 2.7 said, this is an absolute ban on any works that involve maiming or injuring the building. And 3.19, and I'll be referring to this quite a bit, was the covenant which essentially said that where a lessee objects to works, they can make and enforce the landlord, enforce those covenants, which was absolutely proper way of ensuring that things are done. And This is the clause that Dr. Duval wanted to uphold. Essentially, Dr. Duval, she said, well, the lessee next door to me is doing works to a wall, and I request you, the landlord, to enforce the prohibition against such works taking place. The Court of Appeal found in favour of Dr. Duval, and this was appealed all the way to the Supreme Court on the basis that the Court of Appeal had failed to properly construe the terms of the lease in context, and it had applied a term which it shouldn't have done. There are a number of issues that need unpicking, but it essentially comes down to this question. If there is an absolute covenant against doing something, can the landlord give permission for it before a request is made to enforce it by the other party, which might include that party putting up money for such enforcement, i.e., is there a battle of timing? And I therefore need to take you through the Supreme Court's thinking in this case. First of all, it looks at those two clauses, 2.6 and 2.7, which was the qualified and the absolute provision against works. The Supreme Court took the proper two-stage process when looking at whether or not there's an implied term. First, it looked at the express terms in context before moving on to understand what terms, if any, needed to be implied. And at that end, the Supreme Court looked at 2.6 and 2.7, and the first being the qualified covenant and the second being the absolute covenant. The Supreme Court highlighted that almost any improvement works would involve some damage or cut to the wall, but they would not all be major works. The parties at the Court of Appeal had actually agreed the position and said that where there's any overlap between 2.6 and 2.7, and it falls within 2.7, that should be the term that binds anything. But the Supreme Court disagreed and said you had to read those two clauses together. And essentially it said that 2.6 is about the sort of normal works, and 2.7 is works which go beyond routine alterations and improvements. So reading those two terms in the context, it said, of a properly commercial lease that could only make sense. It highlighted, in its reasoning, it highlighted that almost any works could involve some cut to the wall, but it is important to look at where actually the clause 3.19 would actually bite on that absolute covenant, because it wouldn't be right to stop people just doing small improvements. So then it said, where, for instance, the structural integrity of a wall was compromised by the works, that would be a clear breach of the landlord's covenant to provide the stability of the building. And it would therefore need to get the permission of all the other lessees. We now flip back to the enforcement clause, because that's how the Supreme Court looked at it. It said, well, those two terms about the works have to be read together, and then we have to look at how things are enforced. As I said, each lessee had a clause which meant the landlord had to enforce clause 2.7 on request. In the Court of Appeal, the landlord argued that it could authorise a breach at any time it wanted to, because obviously a landlord can authorise works at any point. In the Supreme Court, it dropped that point, and instead it argued that it could also authorise a breach at any time before a valid request to enforce was made, and it deemed a valid request to mean alongside the provision of security or sums of money. The Supreme Court rejected this. It said that a landlord can waive its right to enforce. However, that would not stop it being in breach of its clause 3.19, because it's essentially derogated from grant because it's put outside its control the enforcement of that provision. And it said it would be uncommercial and incoherent that clause 3.19 be stripped of effect by what would be essentially a battle of timing. But what might you say could the landlord authorise? And this is the interpretation of 2.6 and 2.7. The argument goes that the landlord could never allow anything that could cut or damage the wall, i.e. electrical works, but the Supreme Court's view was a bit more nuanced. it said it didn't extend 2.7 because it read them in conjunction, did not extend to routine works. Now, it's very difficult to get the full impact of Duval because in that case, the very specific facts, that involved the issue of a load-bearing wall, which was clearly to do with the structural integrity and clearly way beyond improvement works. But the question is more nuanced in cases such as non-load-bearing walls or works in relation to other aspects. One of the issues that was highlighted was if there would be an electrical rewiring of the property, would that be a major work or not? Because it would clearly involve cutting and mailing into walls, but it might be an improvement that was necessary for a number of different factors. But the impact of this decision is pretty large, where the landlord has covenants to enforce other lessees' actions. It should also be highlighted that there was a freehold company, and will this push the issue of directors to the fore as well? Have they acted without independence? It highlights to me as well that the court is taking a practical look at lease clauses, and it looked at specifically what works would be anticipated in the future. But it was difficult on the dividing line between works that would be major and works that would be minor. And it's not always clear from the lease what works would be which. Obviously, the Supreme Court overturned an agreed position between the parties in the Court of Appeal. And again, that's pretty interesting because that was the agreed position. Also, to put Duval into context, it essentially does give the leaseholders increased control over the estate and what works take place, even when there's a qualified covenant. It might also put directors' duties in the spotlight. Freehold companies are run by the leaseholders regularly. Have they used independence? Have they used reasonable care and skill? Does that open up the challenge? And it also puts into a context of how consent is granted in residential leases. And it's probably important to highlight two cases from the previous years that have dealt with this issue. So you may know that if you have a qualified covenant to allow works or anything else, you have to use your discretion reasonably, and that has to be reasonable both in process and outcome. And this was highlighted in the case of Victory Place Management. That actually dealt with an issue of where there was a ban on pets. Essentially, the lease said you can't have a pet without our consent, and our default policy is no pets allowed. And the court said that in that case, the management company had been reasonable in both process and outcome because they'd asked for medical evidence that the lessees needed this for medical reasons, but none had been forthcoming. But it does mean that reasonableness will be applied to leasehold situations. More interesting, potentially, is the overlap between the Duval case and the Equality Act. Smales v. Cleaver Court, where there was an absolute covenant on works of the property, on no works of the property, but this ran to a degree in conflict with Miss Smalls's disabilities, which meant she needed certain adaptations. The court said that the landlord had breached the Equality Act and a duty to make reasonable adjustments. And importantly, it's not physical adjustments to the property, but adjustments to the process of giving consent to such works. This might complicate matters even further now that we have Duval, and where another lessee could essentially object to those works. So there is likely, I think, to be an interesting case between Duval and the Equality Act and how these two cases interact in the future. Something to be very aware of when giving consent to works or dealing with qualified or absolute covenants in this situation, where similar terms such as 3.19 are involved. So that's the first case. We're then going to be looking at Avon Ground Rents versus Canary. In Avon v Canary, the freeholder was trying to prevent a claim for the right to manage in a block which contained 3 different types of ownership. A brief background to the claim: there were 7 blocks of flats which was agreed formed 2 buildings for the purpose of the Act. there were three types of ownership. There were long lessees, there were shared ownership lessees, and there was two leases to Metropolitan Housing Trust, who sublet a number of different units to social rent tenants. For a claim under the right to manage, you will very well be aware that notice is required to be served on everyone who is a qualified tenant under Section 78. The question in that case is, had this been done? And the upper tribunal looked at three categories of who could be a qualified tenant. The long lessees, they were very easy. Find them and serve them is essentially quite a simple process. The shared ownership lessees, however, were more complicated. There are a number of those who had not staircased, which they hadn't achieved full ownership of the property, and therefore they held their leases alongside Metropolitan Housing Trust. So the question was, who was the qualifying tenant? And then there were the units that were rented out to social housing tenants, and who was the qualifying tenant in that situation. The first tier tribunal had allowed the claim for the right to manage, saying that no notice needed to be served on Metropolitan in relation to the shared ownership units. It was the people in the units who were the qualifying tenants. It also said that no notice had to be served on the Metropolitan in relation to the socially rented units, because Metropolitan was a landlord within the meaning of the Act and therefore couldn't be a qualifying tenant. It then went on and said, in any event, it didn't matter if they hadn't been served when they should have been, because they didn't suffer any prejudice. No, so the upper tribunal disagreed, and it made some different findings to the first tier. And I'll go through those now in relation to each different type of ownership. Firstly, long lessees, really simple, essentially. They are the qualifying tenants, and you can obviously look for them on the land registry. The only interesting comments that the upper tribunal said is that where they've been sublet, Parliament can be taken to have been willing to allocate that risk to the qualifying tenant, that, for instance, the notice wasn't passed on by their subtenant, or they hadn't updated their forwarding address. But obviously, if you're dealing with this on a practical level, forwarding it to other addresses is obviously really important. Shared ownership. Is the person in occupation the qualifying tenant, or whether or not it is the Metropolitan Housing Trust, the housing association? The upper tribunal said, no, it is actually the person who's in occupation, the tenant. And to a degree, this was a rehashing of the arguments in Corscombe Close from a couple of years ago. But essentially it focused on whether or not the provisions under 76.2 A and E are incompatible. And that's because this defines what a long lease is, which then again focuses on what a qualifying tenant is. Essentially, a shared ownership lease that hasn't staircased to 100% was said to fall within a bit of a gap in the legislation. That's because it doesn't fall within E, section 76.2E, because it hasn't staircased to 100%. And there was a thinking that therefore it wasn't a long lease. But what Corscombe Close said is, no, that's definitely wrong, because it clearly falls under section 76.2A, is that it's a lease for over 21 years. Importantly, and for the first time in this situation, that reference was made to the case of Midland Hart, which really does affect how shared ownership leases are seen. But it does say that shared ownership leases will be long leases, and therefore it's the person in occupation who will be the qualifying tenant. In relation to the socially rented units, the upper tribunal stated that there's no doubt that Metropolitan was the tenant of each of those flats. The fact that it was also a landlord doesn't make any difference, and it was a particularly strange argument. The Right to Manage company had not served notice on them, and the upper tribunal found that the provisions of section 78 are strict, and essentially that non-compliance did defeat the claim. And it's important, and I think right, to read out the full quote that's there. And the judgment said it's a matter of some regret that, once again, non-compliance in this case, which does not appear to have prejudiced any of the qualifying tenants, has provided an opportunity for Avon to delay the acquisition of the right to manage at the expense of the members of Canary A and Canary B. There can have been no prejudice to Avon, nor is Avon purporting to act in the best interests of Metropolitan Housing Trust. And what this highlights to me, as they defeated this claim to right to manage, is that reform will change the notices. And this comes straight from the judgment of that case, that actually this leasehold reform will come about, and it will come about pretty quickly. And it will change the notice period, because quite clearly, and if you read the judgment, the judge is quite frustrated that this right to manage application has been defeated by a very technical challenge, which doesn't deal with any of the issues that Metropolitan are reporting to raise. The second lesson I take from this case is that there will also be a change in relation to shared ownership in the future. There's been a debate with Corscombe Close, another case called Brick Farm, and Richardson and Midland Hart about the actual structure of shared ownership leases and essentially legally what they are. The government has announced a consultation about a new model for shared ownership. That's because shared owners face sometimes very, very high service charge bills because they pay 100% of the service charge bills, regardless of what proportion they actually own. It's also right to say that taking possession from a shared ownership lease is not the same as on a long lease. So it can get more complicated. And I think that the government will have to look at shared ownership as a model because it falls at the moment rather inelegantly between long leases and assured tenancies, taking some of the worst of both of those processes. And so I do expect that there will be some changes to shared ownership leases because it's been a sort of flagship government program, but it's not really working as well as it could. My third case of 2020 is something I deal with quite a lot in my practice. And this is where there's a crossover between property and company law or commercial law. This case got essentially piqued my interest because of those reasons. And it's essentially about the blurred lines of distinction between shareholder rights and leaseholder rights. So in the case of Hounsworth Village v Barton, there was a case about whether or not information could be requested by a member of the company for essentially an action that was a leaseholder style action. It's becoming very normal, whether by right to manage, we just spoke about, or the process of enfranchisement, that leaseholders will now manage properties via companies that are all members. It's sort of seen as a way of avoiding the problems of leasehold management. There is therefore an increased focus on individual rights as members of the company and their rights of leaseholders. And it's sometimes meaning looking at those two issues in parallel to provide solutions. And this is not a new problem. It seems to be increasing. I've highlighted there a 2008 case of Moorshead versus DeMarco. And in that case, the courts said that there needs to be a very clear line between the two roles that are operating simultaneously. In that case, the DeMarco, the company there, the Articles of Association allowed the company to levy sums, financial contributions from its members, even though those sums would not have been able to be levied in their roles as leaseholders under the terms of the lease. So it was essentially a way for the company to extract some further sums of money from the leaseholders, but all to do with enforcement. So it's a really interesting and sort of misunderstood role of these companies and what they can do. And it means looking at the Articles of Association really, really carefully. So what do you need to know about the basics of this case? Essentially, Mr. Barton sought information under 116 of the Companies Act 2006. That process allows a member to inspect the register of members, but must state their reasons for doing so. The basic principle behind this is that the members should be able to know who everyone is so that they can communicate with each other. And that seems right, because if there is going to be a challenge around any operation of the company, the members need to know who the other individuals are. And in this case, Mr. Barton wanted the names of the members to have the ability to pass resolutions removing directors and the managing agents. It is quite a simple process, 116 normally. Normally, the company has 5 days to approve a request or apply to the court. And it's obviously very important that those in the leasehold industry are aware of this because of the timescales. The court under section 1173 can say that this request is for an improper person. It's also important to highlight in the factual history of this case is that Mr. Barton had used this section before in the case that I've highlighted there, Pandon Gate. It was in relation to a completely different building, but it had been in that case found that there was an improper motive for his request under 116. At first instance, the court said it could have little reliance on the previous litigation, and that must be right. This is a totally separate case. And it looked at the application and said it was for a proper purpose. Mr. Barton did need this information. The company appealed and argued that the stated aim of removal of the managing agents was not a proper purpose. And reliance was said to be placed on the fact that this was a leaseholder issue and that there was another route to removing the other managing agents. The Court of Appeal dismissed this appeal, and it really said, well, look, what are the limits on the corporate governance of a company? Where a stated aim of a company is the management of a block, quite obviously central to that objective will be the removal or not of the managing agents. So Mr. Barton was fully entitled to have this information for that purpose. They said, essentially, it doesn't matter that there's an overlap between what he can do as a shareholder and what he can do as a leaseholder. He can choose either way to get towards his stated aims. So if he therefore wanted to remove the managing agents, he's fully entitled to request the information about other shareholders to see if they would support his application. And it's quite clear that it was to do with the day-to-day management. Well, this is, I think, quite a growing and interesting trend for 2021. There is an increase in shareholders or leaseholders using company law, and I've definitely seen an increase in that over the course of my practice. There can be calls of meetings for the removal of directors, and that can get quite personal in some situations, because obviously everyone is living pretty close together at that point in time as well, which is quite interesting when you try and unpick all the factual allegations that are made. There is also an increased use of unfair prejudice petitions under section 944 of the Companies Act. That essentially allows minority shareholders to take further steps against the company where a decision has been made. And that's really interesting, where one leaseholder may have been targeted, or one leaseholder doesn't think that they're getting the same treatment as other members, especially those who might be directors of the company. And that's come up a number of times in my practice in relation to essentially the process of companies granting sort of extensions of leases, which are really interesting petitions as well. In my view, there is going to be a growth of these companies controlling blocks that are managed by both shareholders and leaseholders, and therefore there's going to be an increase in the use of company law as a mechanism to achieve results that leaseholders wouldn't get as quickly in the sort of traditional settings or via applications in relation to things like service charges or the like. Company law is a lot more there's a lot more proactive steps that are needed within company law, and it's a lot quicker process. As I've highlighted there's a 5-day turnaround for information, and it's designed to be a very reactive and quick. So it's something that those in the leasehold sector need to be aware of. My final case of 2020 that I thought was interesting was Treacle House versus Randolph. And this is a question about whether or not a gas safety certificate was needed to be served prior to a tenant entering a tenancy to ensure that all subsequent Section 21 notices could be relied upon. This was an ongoing problem in the residential sector. A little brief background to how this problem came about. The Deregulation Act 2015 wasn't particularly deregulating in any way and brought in a whole host of new provisions. One of those provisions was the need for a gas safety certificate for all new tenancies after the 1st of October 2015. It was evident from the outset that the legislation wasn't clearly drafted at all, but it appeared to be the intention of the Act and supported by the explanatory notes that it was only needed to be, that gas safety certificate only needed to be served prior to a Section 21 notice for that Section 21 notice to be valid. It didn't have to be at the start of the tenancy. In effect, though, the provisions were unclear. We were doing quite a lot of work in this area at the time. And we said essentially to our clients, don't worry, just serve the gas safety certificate at the start of the tenancy. It helps from an audit point of view. There are also criminal sanctions that can be put in place, so it's important you serve it at that point in time. Then essentially part of the Deregulation Act said it had retrospective effect after the 1st of October 2018. So there was a real question: if you hadn't served a gas safety certificate prior to a tenancy before 2015, and you had never known of the need to do that, had you effectively granted an assured lifelong tenancy? Because if you weren't able to use Section 21, you had to find a ground for possession. The issue floated about the county court for some time, and it ended up in a decision of Caradon versus Monty Schultz in the county court by a circuit judge. This was actually quite widely shared in the sector, and it's a trend we've seen from the county court where the judgments are actually quite widely shared on these issues and lead to county court judges following the same approach. In any event, Treacle House, the Court of Appeal overturned the decision that said that the obligation could be complied with by late delivery. I've just highlighted the basic facts of the case there, but it's not particularly that interesting, other than the fact that the gas safety certificate was provided too late. The Court of Appeal said it didn't make sense in policy terms for the regulations to have the effect that they were having. And it also highlighted that the sanction in relation to not being able to rely on a Section 21 notice was not the primary sanction in relation to gas safety. There is a criminal offence in relation to those, and it must be read in that context that this Section 21 sanction was essentially a bolt-on rather than the main provision. But it does highlight an important point with Section 21 notices. And there are three aspects to this. Firstly, there has been a massive increase in the private rented sector, and it's quite clear that this increase was related to, in part, the ability to serve a no-fault ground of eviction. In 1988, just 9% of people lived in the private sector accommodation. Now it's around about 20 to 25% of people live in the private rented sector. So that's been an absolutely huge growth. In the last decade and a half, there's been a restriction or regulation on the serving of a Section 21 notice or a no-fault ground. I've put a couple of those up there now. We've obviously got regulations in relation to deposits. You've also got prescribed information that you have to serve. You've got regulation in relation to HMO licensing, retaliatory evictions, rent repayment orders. All of those aspects are restrictions on the private sector in that way. But they are seeming to peter out. Most residential landlords now have a very good grasp of the deposit protections, and the prescribed information is fairly clear what you need to do now, especially after this latest case. But what we've seen during the pandemic is new levels of information and notice needed within the private sector. You already can't evict someone within the first 6 months, and there have been extended COVID-19 notice periods in force for quite a while, and they look like they may just stay there. What's also been interesting is that there's been an increase in the information that a private landlord has to provide about their tenants. And why essentially do courts need that information? Well, it pushes it to a position where the court is exercising their discretion. The court wants to know about the personal circumstances of a tenant, and it's therefore pushing the issue onto the courts rather than on the discretion of the landlord whether to evict. It's obviously not probably meant in this way, but it's definitely a change that's been brought about by the pandemic that is likely to continue. And that is essentially that the court's going to take a much greater look at the private sector and essentially say, well, are we fine with this model going forward? And it does look like the government were very keen to end Section 21 notices, but they hadn't really thought about the process of how they were going to do that. So those are my 4 cases that I wanted to talk to you about today. What do these cases tell us about 2021, which is the crucial thing? I always think in these cases, it's great to tell us what the law was in 2020, but what do they tell us about the challenges that we're going to face in the next year? Well, it's clear that there's going to be first further government legislation on leaseholder rights. That's inevitable, and that is going to come and be quite complex in probably the latter half of 2021. What that does to the market in the meantime, it is very interesting, and what that does to, for instance, extensions of leases in the meantime, again, very interesting, because you think people might be holding off, hoping that there will be a better deal in the future. 2021 is going to be the year of cladding issues and challenges to those, but the question is going to be via what route? What powers are leaseholders going to try and use to get sums of money challenged? Will that be via their company rights, or that will be via the traditional rights that we've seen, or will it be by the new rights in relation to the Building Safety Fund? There is already a complex issue around granting permission for leaseholders to take out works or for alterations or for any issue like that, even subletting sometimes, especially in the case of shared ownership leases. That's going to only increase because of the decision of Duval, and that is going to run up against other legislation like the Equality Act. And finally, there is likely to be an end of the mandatory ground for possession, but that may change, for instance, how the courts and the housing courts operate in their entirety, or it may give new powers in relation to some mandatory grounds on the basis of disrepair or of rent arrears or of the quality of the property. So there's a lot of issues going on from these cases, but hopefully that's been a run through of why I think those cases were important in 2020 and what their likely impact is going to be in 2021. If there are any questions, happy to answer them now. But as I said, if you have questions that either I can't answer or you come and think about later, please get in touch with the team and I will get back to you as soon as I can, really, with those.
Hi, well, there are a couple of questions actually, I can see. So shall I, the first one is, can an RMC insist as part of permission to let gas safety certificates are mandatory for leaseholders who will be letting to enable unsuitable tenants to be evicted?
Sorry, I'm not sure I fully understand the question there. Let me Try and read
Can
through
you
it.
see it on your? Can you see it on the Q&A at the bottom?
I will just check there's a technical challenge. I'm not sure, unfortunately. I understand the question, if I'm honest. I'll have to look into that. What I'm saying is that you're looking for a right to manage company to make sure that gas safety exists. At the moment, that doesn't matter too much in terms of the treacle case says that you can serve it late. So even if they don't have it in place, as a way of ensuring that unsuitable tenants are evicted, you would have to make sure that you're putting pressure on the leaseholder and their rights to essentially assure nuisance and annoyance isn't being caused. A couple of the interesting cases of this year, especially around the pandemic, have really focused on the fact that issues like Airbnb have become a real problem, and it's about proving the nuisance annoyance to the general population, if that's of the estate, if that's what you want to do to pressurize the leaseholder to then pressurize their tenants. And there still is a question about some leases where it's either any nuisance and annoyance, however it's caused, or nuisance and annoyance caused by the leaseholder themselves. And most of the time it's the former rather than the latter. So if you are looking as a right to manage company to ensure that everyone is complying with the law, you would make sure that they all have their gas safety certificates in any event. And you can probably use a fact that it is a necessary sort of health and safety measure to leaseholders to say, look, you really need to get this done. So yeah, that would probably be the way I would answer that one. I see that there's another question in relation to the building safety fund being closed or not. I'd say the first round of the building safety fund closed quite a while back, but now they've announced new funds. I don't doubt that they've got a new process for doing that. One of the issues I think that is going to be key is that it only covers a small amount of the works in terms of it only relates to fire safety issues. And what I've seen of the blocks that have come to my attention is that, yes, there is this horrible issue with cladding or with balconies or fire safety, but then there are massive issues that have taken place because an intrusive survey has found out that the works, essentially the initial works, weren't done properly. And the building contract was never really fully scrutinized at that point in time. And it'll be a question of whether or not the developers are going to step in to underwrite the cost of that, or it will just fall on the leaseholders, unfortunately.
Okay, I've got another one. The future of marriage value. Did you mention anything about marriage value, or did they miss it?
I didn't mention anything about marriage value. That's because marriage value is really technically complex, and something that I have to admit hurts my head when I have to think about it in a big way. I know of people who fully understand it. I'm not exactly one of those. There will, I think, be massive changes to those aspects because I deal with this sector quite a lot, and I don't fully understand how it's all dealt with. In terms of the premium, when you're looking at the 80 years and below, it's a little bit easier, but it's not all that straightforward. And I think that's one of the problems that the government are trying to say, well, look, you can't read anything to make sense of how that is going to be assessed. So how are we expecting individuals to take control of this? Or are we always going to make it expensive because we're passing this into the realm of experts? And it's not even expert lawyers at that point in time, it's expert surveyors and valuers. So there will be, I think, changes to that area just because it's at the moment far too complicated for an individual to do it on their own. Though the problem will come is if someone's waiting at the moment to, well, they're on sort of 82 years left or something, are they going to wait for 2 years to see if a change comes, or are they going to press the button now to do it? I don't know if I've got the guts personally to wait, but I'm pretty risk averse, as you may tell by my job. which is essentially surrounded by books and the law. So yeah.
We've got one more. So they've missed the first bit of your cladding. So how can leaseholders challenge payment of remedial work to cladding falling on their shoulders? Have there been any successful cases against the developer where the building did not comply with building regulations at the time of construction? Freeholder ? And is there any useful case law precedent to date?
Ooh,
big question there.
Big, massive question. Sort of a huge talk in its own. We at 5 Paper have done a talk on cladding, and it lasted for about an hour and a half and involved one of our QCs as well. At the moment, as far as I'm aware, there haven't been the cases against developers about what they did at the initial stage. The essential, very, very basic point is that at the time of building, they didn't do anything wrong because the regulations were different. So they built a property that was entirely compliant with the regulations that were there. Now, if they did something wrong at that point, there is a different argument. But there have been about, I've seen in the news, 3 or 4 developers who said they'll cover the cost of these types of things. And interestingly, the National Housing Insurance Policy has covered some of these issues under defects guarantees. It's quite interesting as well. There's not a lot of news about that. And it seems that there's a sort of wall of silence that's gone up with potentially NDAs. We obviously don't know if there's NDAs because you will never know if there's non-disclosure agreements in relation to these settlements. But there's a bit of a wall of silence. There's nothing in the courts so far. There may well be challenges, but I think they're going to be slightly delayed by the fact that most people will try to use the Building Safety Fund before the other routes. Essentially, where the case law has said, where a freeholder is taking any actions, or whether that be waking watch or anything like that, essentially the full cost can be passed to leaseholders. Because that's within the service charge mechanism. So there are some really staggeringly large bills that are being passed on. There was a couple of cases in Manchester and a couple in London as well, which essentially said, we sympathise for you, but the freeholder can get all the money back from the leaseholders. But it has its own obligations under insurance, but that's not part of the tribunal's discretion. It's been a very one-way street in that predicament for leaseholders, and that's why essentially the fund was set up, because it looks like it could be ruinous for some people, really, unfortunately, which is heartbreaking because there's nothing they could have done to know that these properties were an issue. Lots of them are built off plan, sort of bought off plan, I'd say, and it's so hard to challenge what's gone next. What I think is important to hold your freeholder to account in relation to any applications that they are making in relation to any of these funds that become available, because that's going to be, as bad as it sounds, the most practical, cost-effective way of dealing with these things. And I was just speaking before when we were talking about this. One of the things I was looking at was the statistics on the Building Safety Fund of its previous iteration, when it was, when I say only, it was only 1.2 billion, I think, but that was judged to be around about 10% of need. But essentially a lot of the applications had fallen short because they just didn't go through the process in the proper way. And that's going to be really interesting because the one clause of the Building Safety Fund bill that's going through says that a freeholder has a proactive duty to apply for all funds that become available. And let's say, for instance, they send it late by 2 days. Then who does the leaseholder claim against? Do they claim against the freehold because actually they've not complied with one of their duties, and that has cost them thousands and thousands of pounds? And in that situation, what would the freeholder do? Practically speaking, the freeholder is likely just to essentially become insolvent. It's going to wind itself up because it won't be able to finance this, and it will disclaim the lease. That's all it will do. So it's a really complex pattern of how you control and enforce people, knowing that we're talking about such large sums that are involved. It can be ruinous for a company, and it can be ruinous for an individual, and that can lead to further steps with enforcement, which are really difficult.
Well, on that happy note, sadly.
Yeah, but there are some good points. I mean, I think as I say, the 2012, it's got to be nice. The 2021, the changes that will take place in leasehold management will be interesting, but I think they will reduce the costs and complexities of some of these issues, which will hopefully be quite good. And I actually think that having more company law in relation to leaseholders will actually be, those issues overlapping will actually be more interesting and more useful for leaseholders, because they will be able to control the process a lot more. And I think many of the disputes I see with leaseholders is that they essentially feel so trapped by not having knowledge or control or any agency over things, that small issues can then get much larger, especially because you see these big freehold companies sometimes not communicating in the way that is the best for leaseholders, because it's too hard to understand. If you give people agency and you give people control over these things and a say in it, then actually they work really well. So some of the best blocks that I deal with in sort of my other guys is where we deal a lot with cooperatives, and that's a different form of housing management. But essentially, they all get really high satisfaction scores because they're all integrated into the management of it all and can deal with issues quite well collectively. So I do think those will be really positive changes to 21. The trouble is, our industry is got this cladding issue and fire safety, which we need to take forward importantly, but it's falling on the wrong people at the moment, in my opinion, and that is always going to be a problem in the next year.
I think you're right there. I think you're right, and we'll be covering more about that on Thursday. We've got 2 sessions on Thursday to look at that. Well, look, thank you so much, Tristan, for your presentation today. Very useful indeed. We've got your colleague on this afternoon. We've got Elizabeth England, and she's going to be talking about service charges later, a proportion based on fair proportion. So we hope, if you haven't already registered, go to newsontheblock.com/events and training, and you can join us there. Well, thank you very much, Tristan, and we will hopefully see you again at another one of our events very soon.
Thank you very much. Thanks for having me, guys.
Thank you.